People v. Ehinmiakhena.
Good morning, Your Honors.
Morning.
Christina Schwarz from the Legal Aid Society for Appellant David Ehinmiakhena. We're going to request 3 minutes for rebuttal.
Yes.
This case is a straightforward, routine, uncomplicated Fourth Amendment case.
Can I ask you, please, what your remedy is? What relief are you seeking? Are you seeking the dismissal of the accusatory instrument? Are you seeking remittal for a hearing? That, to me, is not so straightforward from your papers. I'm not sure what you're asking for.
We're asking for dismissal. In the alternative, we would allow we'd be happy with the remittal for the hearing.
Okay, and what's your authority for dismissal?
Well, I mean, I will agree with you that we're a little bit out on the limb when we say that their response was not sufficient, but their only response was boilerplate language. And so based on that, it really seems like they haven't established or really contradicted our version of the illegal violation of and stop. But the other authority would be the Burwell relief. In this case, Mr. Ehinmiakhena pled guilty to a traffic infraction.
That he could still go to jail for, right?
Well, he's already paid the fine, and that was 10 years ago. He hasn't had any issues with the law since then. So it seemed because of the de minimis nature of the traffic infraction, we would ask for dismissal.
Counsel here, what exactly are you asking to be suppressed?
All of the observations that occur after the
So
stop.
what would they be here?
So in this case, it would be the defendant behind the wheel of the car in the driver's seat, key in the ignition, engine on, handing over his driver's license and any other.
Why handing over his driver's license?
It's equally an observation of culpable behavior. In this case,
How is that?
I'm sorry, let me give you a hypothetical. Let's say in this case, and it's not your case, but in a different case, instead of saying I saw him in the car with the keys in the ignition, they put in the complaint that I reviewed toll data and I saw this car go through the toll plaza immediately before the stop. I pulled him over, and this is who was in the car. What do you suppress there?
Well, in that case, maybe I don't quite understand your hypothetical, but you're saying that they had a reason to pull him over that they ahead of time?
In the complaint, and all we're talking about here, right, is what they used in the complaint, right?
Yes.
So in the complaint, instead of, I saw him in the car with the keys in the ignition, motor running, they say, I reviewed tape, I saw this car go through a toll plaza, this license plate, this day, this time. 5 minutes later, I pull him over, or 2 minutes later, and he hands me his license. Good or not good?
Well, I would still say that the observations that
But in that hypothetical, the observations are pre-stop, right? The only post-stop observation would be, I think, consistent with your argument that, taking the license is also some sort of interrogation or search.
okay, I understand the hypothetical. The pre-stop observations are not subject to the exclusionary rule, so of course they could come in.
And so what would you seek to suppress in my hypothetical?
In your hypothetical, I would still seek to suppress those observations of him behind the wheel of the car because those are the strongest evidence.
But they don't use them. They don't use the observations behind the car. They only use the toll data. The photo of this car going through, you can't make out the defendant, but photo of this car going through 2 minutes before the stop occurs.
Those pre-stop observations of the grainy traffic cam pictures are not as strong of evidence as the evidence.
They don't even use that evidence that you're talking about. They don't use behind the wheel, keys in the car.
Then
All
what
they
I
use
would
is
think would
license plate reader through the toll, 2 minutes. I'm right here, I'm the cop, I see that car come by, I pull it over, it's Joe Smith.
Well, they have to prove that he was the driver of the car. The strongest evidence of that is those close-range observations.
Well, that's whether or not they prove their case.
Right.
But the question is, given that all the operational observations were pre-stop, would you be seeking to suppress anything here today in that case?
So in your hypothetical,
Yes.
In that
hypothetical
hypothetical.
there,
Yes.
I would think that in order for that to fly, they would have to stipulate that they were not introducing any of the observations that, and that CPL 71060
Not in the complaint.
requires
They don't
that.
have to stipulate to anything. It's not in the complaint.
Right.
So they're not using them to get what they need to get through this complaint, which it seems to me is what this is about at the end of the day, right? Because without the observations, your argument is there's no support for the complaint, right?
Yes, but suppressible fruit is evidence culpable. It's evidence of culpability, and it's a broad definition. It's anything
seems
that's
to
gained through
me-
exploitation.
It seems to me we have a couple of different kinds of observations at issue here, moving away from the hypothetical for a minute. One is the observation of the defendant behind the wheel of the car, which may give rise to a finding that he's operating it. The second, I think, is the handing over of the license. If we focus only on the second, is your position that that specifically is suppressible?
I think all of the observations.
I'm asking only about the handing over of the license. My question really is, how is that distinct from ascertaining the defendant's identity, setting aside the other observations?
So all of those observations of behavior are,
I'm just asking about the handing over of the license.
okay, so the handing over is still evidence of culpable behavior, so it's still suppressible fruit.
How is it different than ascertaining identity?
So the Tolentino case laid out the rule, and it is actually a very clear rule to understand. The evidence that they are calling identity evidence that's immune from suppression is evidence that's based on jurisdiction, who the person is, the person before the court. The case variously said it's pre-existing.
So if the officer asked, "What is your name?" Would that be suppressible? That seems like that's identity.
It would be suppressible because, again, it's culpable conduct. All of the identity evidence in Tolentino were pre-existing records, things that flow with who you are. They're not unique. That means they're not.
I want to go back
tied
to I want to
the
go
time
back
and
to,
place.
to where Judge Singas started from and approached a little bit differently. And maybe I'm just thinking about this too simplistically, but it seems to me that if the people say, we're not conceding that this stop was unlawful, but even if you assume it was, and then they go from there. But isn't it the case that if they have a reason to stop the car, asking the driver to hand over the license is unquestionably lawful? And if they don't have a basis to stop the car, then everything gets thrown out. Isn't it that simple? And if that's right, then why are we worrying about whether this is identity or not? The real thing we have to do is send it back so that we can determine whether the stop is lawful or not. That's the way these normally proceed.
Yes, but what I would agree that would solve it. But the point is that the court below, when they issued their ruling, vastly overstated the scope of the Tolentino rule, and this court can make it clear that it is for a very distinct and small subsection.
The court
of
below said
evidence.
something in substance along the lines of identity is not suppressible. And it didn't, I don't mean to characterize your argument, but it didn't parse identity the way you do, which is this sort of objective, pre-existing status of who you are versus law enforcement trying to figure out who you are.
culpable behavior,
which you will call culpable behavior.
which is what you did. And
But correct me if I'm wrong. Tolentino does, it has some good rules in it, but it doesn't go that far. It doesn't parse it out the way you're parsing it out.
well, I would just point to that Tolentino does try to explain it and gives multiple examples of what is identity, and they're all information that's not tied to the time and place of occurrence. It's unique and it comes with the person who's in front of the court. But the Tolentino court did provide a good explanation of the distinction between the evidence identifying an individual as a perpetrator of a crime, the what you did stuff, from the other jurisdictional identity evidence, the who you are, when they were talking about the Davis and the Hayes cases, the cases with the fingerprints, and they were explaining why the fingerprints in those cases that were elicited in order
What did the prosecution rely on at the suppression hearing to establish the legality of the stop in the first instance?
They provide, it was just boilerplate language. We don't know. There's no evidence of what they did. But I'd just like to get back to,
excuse me, should they get another opportunity to present that evidence?
well, if a hearing had been ordered, then they're claiming that they
could have
had
done
a
that.
reason. We don't know what it is, but at that hearing, they would provide that. And that was the basis of, because it was such
In their
boilerplate
response, they didn't
language.
set out what are the grounds for why it was a lawful stop?
There's one sentence.
But they did dispute that it was unlawful, correct?
Right. They said, this is what I mean by boilerplate language. In their response, they said, the people deny that the defendant was illegally stopped, apprehended, and/or arrested. And that's on page A11 of the appendix. So very boilerplate. We don't know anything
Is
more
it your
than that.
position that's why the suppression motion should have been granted, because they did not establish the legality of the stop with that response?
We made arguments that that Gruden would permit the court to have granted summary suppression.
Okay.
But in the alternative, a hearing, but the court, vastly overreading Tolentino, denied the hearing in its entirety. I want to get back to that language from the Tolentino court because I think it will solve the confusion, because the court then says on page 387, at the bottom of the page, the court says, the evidence establishing defendants' identities as the perpetrators, but not their identities in the sense relevant here. And again, that was they were distinguishing with the fingerprints that had been taken from the defendants so that they could investigate ongoing crimes. And they were saying that those fingerprint evidence was evidence to establish their identities as the perpetrators.
Counsel, excuse me, did you say page 384?
87.
87.
387, yeah.
But
yes.
the charge, one of the charges, at least in that case, was aggravated unlicensed operation of a motor vehicle, right?
Yes.
And how do they know that unless he was the person driving?
Right. There's two elements to the crime in this case. One is driving the vehicle, and the other one is that their license was suspended. The license suspension evidence would be proved by
DMV.
the DMV records, Tolentino, not subject to
But
suspension,
how
but
in
the other
Tarantino
evidence
did they
is
prove that he was aggravated unlicensed operation of a motor vehicle?
the DMV records alone
But
introduced.
how did they know he was driving?
The identity in all cases is the jurisdictional element. It's not needed to be proved.
Did defendant challenge that? What I think Judge Garcia is asking about, the connection of the dots between the DMV record says this person, Mr. X, right, can't be on the road, license suspended, and the connection to, oh yes, the person behind this car is Mr. X.
Or handing
That goes back to Tolentino. That it's an uncontroversial bedrock principle of law that identity is
let me
not-
ask you this.
No,
Okay.
but I'm sorry.
Let me ask you.
Can we just follow up on that? You say that, but then you say you can't have the fact that he hands the license out the window. Nothing from the stop can come in. So what in Tolentino gave them the unlicensed operation?
in Tolentino.
Right. If it wasn't, I pulled this person over, and maybe I don't understand the facts of that case, but they charged that defendant with aggravated unlicensed operation of a motor vehicle. So how did they prove the operation part of that?
Are you talking about the case here?
Tarantino.
Well, that case was never tried, so we don't know, but it was not the subject of the suppression motion in that case. They never asked to suppress these observations. They only asked to suppress the DMV records in a motion that was sort of a map-type motion seeking the physical evidence, the DMV records, to be suppressed, and that was the subject of that case. Now, 10 years later, we have this new case where they're not asking for the suppression of the DMV records, which are not suppressible under Tolentino, but they're asking for suppression of the observations, which are clearly suppressible under Gethers, Rossi.
Where do you see those
decades of-
observations? Where are those observations? Because I'm looking at the complaint. There's nothing about the officer saying he saw them hand the license.
It's at the front of at the very top of the complaint. The complaint says that
Can you tell us what
they
page of the
observed the
record?
defendant operating a motor vehicle, and then in parentheses, this is on page A4, sorry. In parentheses, it says the key was in the ignition, the engine was running, and the defendant was
Is that
behind the wheel.
pre-stop or post-stop?
It's post-stop. Those are not the sort of observations that would be made by a car that's whizzing past.
I'm sorry, counsel. You answered the question. I really want you to get to the part of the complaint where they're talking about identity, because everything you've been talking about so far has been operation of the vehicle. So where does the
handing
complaint
over
talk
of the
about the
license
identity
plate.
part?
Handing over of the license, I don't see anywhere.
There's no need to prove identity. Think about it. In criminal cases across the, there's not, that people aren't putting on evidence to prove who the person is, because that's the jurisdictional underpinning. That's the jurisdictional underpinning of the case. It's a given. It's that uncontroversial law.
So
that-
why doesn't it follow from that taking a license, the defendant handed over the license, why doesn't it follow that that's just part of identity?
Because it also establishes culpable behavior. It is an observation.
What do you mean by that?
Because it's
I don't understand that.
in a car that was just stopped, where the police approach and they're handing over a driver's license. That's clear inferential evidence that that person is the driver of the vehicle. And the only element they need to prove here without the DMV records is operation or driving the vehicle. It's directly relevant to establishing the fact-based element of the crime. So yes, it's highly inculpatory under the circumstances of this case. And the district attorney suggests maybe we could excise out all the other evidence, but it's just inculpatory to have at the rest scene in the car, handing over the driver's license, even if they don't mention that the key was in the ignition.
So
the jury's going to
you would then agree, I know it's not the posture of the case, that if the officer, you said the car was whizzing by. The car wasn't whizzing by. It was going by, and the officer's neck, driving also by, looks over and sees that driver. You would agree that is, and then stops. That pre-observation, oh yes, the defendant is the person I saw behind that wheel before I stopped. You agree that they could testify to that, yes? Or that could come in?
For sure, but the strongest evidence of driving would come from those close range observations that occurred after the car was stopped. But for sure, if we won the suppression hearing, they could proceed with I think the respondents mentioned some of the things, the pre-stop observations, maybe traffic camera footage, but those things are much weaker than that strong, direct observations of the officer
You
at
agree
the
they
side
could,
of the car.
you agree the prosecution could attempt, nevertheless, to make out its case with that kind of evidence.
But
Even
they
if you
just
think it's
wouldn't.
weak, the prosecution may think, under the circumstances, I don't think it's weak, I think it works.
Well, I think that's a ridiculous and
What I would, what,
utility
police
because
officer is
in this
is
case they,
stationed, excuse me, next to the car. Let's say they're both stopped at a red light, looks over, looks at the person, maybe the person turns and looks at them, and then after they go through the light, that's when they're stopped. That's ridiculous to base the identification on that observation?
There
Pre-stop
are
observation?
examples, for sure. And another example I would give you, like if they were under surveillance for a long time, maybe the pre-stop observations would be enough.
But,
But that's certainly not
Counsel,
typical.
I'm sorry.
So
Counsel,
I would just say in the typical car
counsel,
stop
counsel,
case.
I'm sorry. In that hypothetical, wouldn't you still say the identity is suppressed? Not the identity, but the handing over of the license in Judge Rivera's hypothetical.
Yes.
So it wouldn't matter that they saw the person before the red light, right? It wouldn't matter.
The pre-stop observations are not subject to,
Right, but the idea, because here's the argument they made in Tolentino as the court relates it. The steps required to obtain DMV records check are the stop of the vehicle and the elicitation of the driver's name or the driver's license number. So you're correct, they were seeking to suppress the DMV records, but the hook they were using for that was you can't ask them for their license, right? That's the argument they're making. You illegally stop the person in Tolentino, you use the license and the ID, handing over the license to get the DMV records. So the DMV records had to be suppressed. And we rejected that argument on the theory that, if you read their argument, we weren't suppressing handing over the license.
well, that's not exactly what happened in Tolentino. In Tolentino, those observations were not at play. They were not discussed. Defense attorney didn't seek to suppress
This is a
them.
quote of the defendant's argument in Tolentino, that as a result, they stopped the vehicle, they elicited the driver's name or the driver's license number. That's a quote from their argument.
Right, that's what happened. But in Tolentino, they were then saying, and they got the identity, and from the identity flowed the DMV records.
But they wanted to suppress the
The
first
DMV,
step
no, they did not.
because it led to the DMV records.
They
That's
should
how I
have
read
done that.
argument,
And that's
as a
what the
result.
court in the Supreme Court suggested. They said, you're seeking to suppress the wrong thing. You should have sought suppression of the observations. Instead, you're only seeking suppression of the DMV records. So that's why here, in this case,
So this is
the
you
defense attorney got it
arguing
right.
what the Supreme Court was, what I think was Justice Scalia was saying that you should be arguing. Is that this appeal right now?
No, that's the Tolentino case. So the point is in Tolentino, which only created a small carve-out for this identity evidence that's jurisdictional, that's about the DMV, the pre-existing records, the records that are not unique to the case, so they're not dependent on what happened. They're the who you are evidence is not suppressible. Everything else that establishes culpable conduct, that evidence is subject to
Counsel,
suppression.
just so I could be sure, can I ask you this question? If your adversary gets up and, as you, I think, intimated a little while ago, says, I'm not challenging suppression of behind the wheel, keys in the ignition, engine running, those things, I choose not to challenge those on this bill. Do you still have an argument in front of us?
Yes.
And that is what?
Okay, the first argument is that that's not what that doesn't comport with the record that was made
Okay,
below.
but let's say the universe changed and now they're not challenging any of that.
So it doesn't comply with the record below, and it also would have required them to stipulate that they weren't seeking to introduce those observations, which they didn't do. So, but then looking at the merits of this theory that they've floated here in the appeal to this court, the handing over of the driver's license is still an observation that establishes culpability. So even if they say, we don't want all these others, but we do want the handing over, it's still an observation that was
Well,
a
I don't think
smaller
they're going to say
subset of
we
it.
want the handing
and
over.
the
I think they're
hearings
going to say that
required.
that's not suppressible. We've already held Tolentino that that's not suppressible. That's how I understand the argument anyway.
Well, Tolentino made it clear they were not seeking that the evidence that rule pertained to was not about what happened. And the handing over the driver's license doesn't fit into it. It's a wild over-reading of Tolentino. Tolentino was this small subset. It was like for identity, who you are, your body, your name, and evidence that flows from your body or name, like pre-existing DMV records, maybe your social security number,
Your name.
things like that, not suppressible. But the constitutional protections of the exclusionary rule applies to everything else, including observations. And that's what Rossi says, that's what Gethers says, that's what decades of Fourth Amendment jurisprudence say. And so we were seeking.
Except your rule, I don't know how it helps the defendant unless they weren't the only person in the car. Because the natural inference is going to be that they were the driver. How else are you getting a license?
Right, and that's my point. It's obviously inculpatory, and so that if they want to introduce it, they need to prove its constitutional soundness. It's not insulated from constitutional inquiries because they can say it's identity related when it doesn't fit into that narrow jurisdictional who you are kind of evidence. It's really a what you did. You handed over the driver's license. It's suppressible fruit because it's culpable conduct. And you make a great point that it's highly inculpatory in a driving case. And the thing is, if their wild overreading of the definition of identity evidence is expanded to also include these observations, the upshot of that is that there will be no constitutional protections for a vast majority of traffic cases.
What public policy is furthered by your rule?
I'm sorry.
What public policy is furthered by your rule? Is it the concern about disincentivizing unlawful stops or something else?
Well, I would just point out that we're just asking for application of rules that already remain in effect. So we're asking that suppression of the hearings
Well, if this wasn't
continue.
at issue in
So, and
Tolentino, it may be an open question, but, right? If you're saying, I thought your response to many of the questions, and certainly I think in response to Judge Garcia's questions, was no, Tolentino didn't decide that because the defendant never argued that. It wasn't an issue in Tolentino. So
Right,
doesn't that
it
mean
just
it's an
wasn't
open
raised.
question?
At
Least in this court, as to whether or not turning over a license is subject to the exclusionary rule?
Yes, it was not discussed in Tolentino, but it is being discussed here because
Because
defense
that's their
attorneys
position
learned
now.
It's an issue now, and it
That's their
wasn't an
position
issue
now.
there. But we know the answer to it because the Tolentino decision is very clear. They're just creating a jurisdictional rule that you can't hide who you are, and so you extend that just slightly to, so if you can't hide who you are, you can't hide your pre-existing driver DMV records, your immigration records, all of the stuff that is inherent in who you are. That's what Tolentino was about, period. The idea that Tolentino also included observations is a wild misreading and a dangerous one because—
But the only way you know who you are is because of the stop and they were in the car. Again, unless there are two people, the natural inference is you're the driver, or at least two people.
Those are the observations. That's the distinction is the who you are, so name, which is not suppressible, that it brings a person into the who's in court in front of you, really has nothing to do with time and place of occurrence. It's just the person in front of the court and evidence that flows from knowledge of the person who's in court. So the DMV records, fingerprints that are not used for investigative purposes.
What's subject to the exclusionary rule is how the officer found out who you are? Is that what you mean?
No, the other evidence, if it's evidence of culpability, then subject to suppression. So the broad rule for suppression is that it includes all fruits of an illegal search or seizure, evidence of culpability gained through exploitation of the illegality. So it's the evidence of culpability, and in this case, handing over the driver's license.
You didn't make that argument below about the handing over of the license, right? That argument's not preserved, is it?
It certainly is because
Where?
they sought suppression of all of the post-stop observations, which of course would include everything that happened while he was seated in the driver's seat of the car engine, that's what was in the complaint.
I thought your position was that this is the first time they make this argument about the license, however, is not subject to the exclusionary rule, the turning over of the license and the information on the license. I thought you were saying that's a, newly crafted for this court.
No, well,
You may not have used newly crafted, but I thought your position was they did not, the record doesn't support
I may have
their
misspoke.
argument now.
the respondent below broadly argued that post-op observations.
No, I understand that. Yeah.
Here in this court, they're now saying, oh, we agree post-op observations generally can be suppressible fruit.
Right.
We're only seeking this little.
Right, so they're arguing this is
subsection.
not, this doesn't fit
And that doesn't. That's
law,
not what
that
they
rule.
said. And since they're now.
So then in response to Judge Singas, how is it you preserve the argument if your position now is they never raised that? How are you responding to what they never raised?
We've always asked that the observations that were obtained after the illegal arrest should be suppressed. Our position has never changed. The answer is conduct the hearing. But their newness is they say that they now were going to allow in all of they weren't going to introduce the observations except for this one little one. But this one little one, it doesn't solve their problem. If they don't want to have the hearing, they still have to have a hearing because that little observation of handing over the driver's license is still culpable conduct, still subject to suppression, still requires a hearing.
So
It
does
doesn't
that
get
mean
what
if
they
we
want.
agree with your legal argument that the remedy here would be to remit it back to I don't think there's ever been a determination whether this was a legal or an illegal stop, right? So we don't even have the baseline for determining whether there's something to suppress here or not. So would that be the remedy? Send it back and figure out whether it's an illegal stop and whether the evidence should be suppressed?
We're always going to ask for dismissal. This is a 10-year-old case. I can tell you my client really doesn't want to come to court, but
If we're not interested in dismissal, that's an option available. to us,
then
right?
remand would be the
Because we're setting up a
alternative.
rule that will apply beyond your, I certainly appreciate your client's situation, but
Yeah,
that they didn't necessarily create the 10 years, but nevertheless, we're trying to set up a rule for other cases.
absolutely. And remand would be the appropriate remedy here, for sure.
Counsel,
We won't contest that.
what if the officer realizes they had no basis to make the stop, and they have the license? What do they do?
Well,
Because you say handing over the license suppressed, so I can't use this. Here's your license. Thank you. What happens? I give it back. I'm the officer. I give the license back. I didn't have a reason to stop you. I now know you're aggravated, hypothetical. You're guilty of aggravated unlicensed operation of a motor vehicle. But the only reason I know that is because you handed me your license. I now realize I couldn't stop you. What do I do?
okay, well, in the real world, that would never happen.
Okay, but in my world, what happens?
But in this hypothetical, it would be wise for the hypothetical driver to call a friend to drive away.
But what say he just drives
if they
off?
didn't, if they drove away, we get to be litigating attenuation.
No. So how far? I have to let him drive 3 miles? 4? That's the rule? 'Cause
Just wait for a traffic infraction and then pull them over?
Well, here's an example.
didn't
In
signal
a small
when you
town
turned.
like Andy Griffith's, Mayberry, North Carolina, where the sheriff knows everybody and knows who has a driving record, that's not enough
but I think this
to
was
arrest
Manhattan,
one
right?
of his citizens. But if he does see that citizen in the car driving, he's got
Yeah, but we're in Manhattan,
probable cause.
right? We're in Manhattan, and I know this person is an aggravated unlicensed operator of a motor vehicle, and I have to let that person pull off the shoulder of the road and go a certain amount of time until perhaps they commit a traffic infraction, or maybe I have someone the next day follow them.
I mean, it's going to have to be litigated, but the information gained through exploitation of illegality can be used, but the question is attenuation. And I would think if he stopped him immediately, it wouldn't
The
be
difference seems
enough.
to me, in a gun case, like you take the gun and it's contraband in sight, and then you can argue, later, you're not going to let somebody drive off with a gun. but you're letting someone go that you know is in the process of committing a crime.
Okay, that's why your hypothetical is really unfair, because that's not going to happen. And like I said, phone a friend, park the car. They're not going to do that.
Counsel, it is going to happen. If the crime is one where your identity is wrapped up in the commission of the crime, such as aggravated unlicensed operation of a motor vehicle, 'cause you're the person who has to have the suspended license, it's going to happen all the time.
No, but it is not an ongoing crime like being an undocumented individual, being illegal reentry. In those cases, it's more problematic because that is an ongoing crime. This isn't an ongoing crime.
That's criminal
They can't
behavior, what you just described?
I don't know if it's criminal behavior, but illegal reentry is an ongoing crime, ongoing status.
Violation of the immigration laws.
Thank you, status.
know that you'd say it's a
misspoke.
crime, but okay.
And thank you. I didn't mean to say that.
I understand.
But in that case, it's ongoing. That's what an ongoing crime is. In this situation, it's based on time, a particular time and place of an occurrence. So you can't just say, like in
You can see
Mayberry,
the
North
conundrum
Carolina,
as a
you have
policy.
driver's-
You can see the conundrum as a policy matter, right?
Well, no, I don't really see it because.
Letting someone get on the road who, under the law, is not supposed to be on the road.
But what's good? But what would happen here is he would be arrested. The case would go into court, and maybe there'd be a
then the
suppression
ex-
hearing to determine. There's no. It
And
isn't
maybe
gonna
it's
be-
excluded, maybe it's
it's
not,
not-
is your
and-
position. They just
and-
arrest them and move forward with the law.
right. But that I don't think there's any policy, and if there is a policy, we want to issue here the maintaining the police are not stopping people willy-nilly, but making stops that are constitutional is really what we're talking about here. And that brings me to the amici brief that was prepared for
I think
this
maybe
case.
I'll ask you to save that for your rebuttal. We've gone quite a bit over.
May it please the court, Brent Yarnell for the people. I'd like to start with the evidence at issue here. On page A13 of the record, we have the prosecution's response to the defendant's motion papers, and the prosecutor says that the only post-stop testimony she is seeking to elicit from the officer is that the defendant handed over his
So
driver's
is that how
license.
you would, you have to prove operation, right?
You have to prove
And
operation.
so is that what you would use to prove operation?
Well, we don't know because the case didn't go to trial, so we don't know what.
But if you are telling us, I think, that the only evidence that you would seek to rely on here is the handing over of the license, are you saying you might seek to rely on the observations that the defendant was sitting behind the wheel of the car?
No, I mean, what we're saying is I think the best read of the record is the prosecutor made a strategic decision
Okay.
based on the pre-stop observations and the handing
So
over.
if the only evidence then is the handing over of the license, I take it that that's what you would argue is sufficient to show that the defendant was operating the car.
Well, the fact that the operation of the car, we would argue, would have to come from the pre-stop observations of the officer before.
But you need to show that the defendant is operating the car, not just that the car is rolling along, right?
You need to show that defendant is operating the
Okay.
car.
The reason I'm asking is I'm trying to understand how the observation at issue, which is the handing over of the license, isn't something that you would use to draw the same inference that the other observations of the defendant sitting behind the wheel would yield, which is that, in fact, it was the defendant driving the car. Am I missing something?
Well, I think if you have a case where, say, it's a police officer on the street seeing seeing cars drive by.
That's
before-
not what we have here, is it?
Well, we don't know because the case.
Well, in
didn't go to
this
trial.
case, is it theoretically possible that the officer, we don't know because it never really got that far, but the officer could say, I would assume, I observed the defendant driving the car, sitting behind the wheel, car was in motion, he was operating it. After I stopped him, I asked him for his license, or I obtained his license, and that's how I found out who he was. So you have your pre-stop elements and your post-stop elements of the crime. Is all of that legally possible?
Yes. I mean, I think what Tolentino says is that you are allowed to attach a name to the person that you stopped. You are allowed to attach a name to the subject of the law enforcement encounter.
But if what you then look to do is to use evidence of handing over as evidence that it was the defendant driving the car, then why are we in any different place than we are with respect to observing the defendant sitting behind the wheel of the car?
Well, as Tolentino says, the identity of the person who was stopped is not a suppressible fruit.
But that's distinct, isn't it? I mean, isn't the question of the identity distinct from the observation that the defendant handed over the license, from which, as I think you heard in several exchanges here, a fact finder might reasonably infer from that fact that it was the defendant driving the car?
Well, I mean, the Supreme Court in Hibble said that a defendant's production of an identification card is evidence of the defendant's identity. It is.
I'm asking you, though, could you use it to prove a different fact, which is operation, not identity?
I'm not sure that you could. I think you would have to use it to prove the identity of the person you stopped. The fact that the person you stopped had been operating a car would have to come from pre-stop observations. And I think the natural reading of the record here is the prosecutor made a strategic decision that with only the identity evidence as being the only post-stop evidence, she could prove operation of the car from the pre-stop observations.
Well, when there's only one person in the car, and that's the person who you obtain the license from, how do you extricate that from operation? Who else could be operating the car?
Well, I think what you would say is that the pre-stop observations in that case established that a person was driving the car, and the post-stop observations simply attach a name to that person. That is simply means that, as Tolentino says, the only evidence gleaned from the stop is the identity of the person who was stopped.
So you don't need, to the extent, are you saying that to the extent that you need to prove operation as part of the crime, you don't need any inference of operation that you get from obtaining the license?
Well, I mean, the only inference would simply be that the name is attached to the person who the
No, that's
officer-
identity. That's something else, Tolentino tells us.
Well, I mean, I think what Tolentino clearly envisioned is that suppression would simply not apply in a case where the officer had seen the defendant driving the car, learned his identity. I mean, the facts of this case are identical to the facts in Tolentino. The facts in Tolentino are that the officers learned defendant's name when he told them his name during the stop, and then the officers used that information to get the license. And Tolentino's reasoning was that the reason that the license was not suppressible, the DMV records, was not suppressible, is because the name was not suppressible. I mean, the facts here are indistinguishable, and what we're here talking
Maybe
about
the
is...
difference is that there is an effort to suppress the observation of the handing over of the license. What's your position as to whether the observation of the defendant sitting behind the wheel of the car is suppressible?
I mean, I think that you could make an argument under Tolentino that Tolentino equates the person sitting behind the wheel as...
So is
the
that
driver
your
who was-
position, that those observations are not suppressible of the defendant sitting behind the car, the wheel of the car?
I mean, I think I think that our position would be under Tolentino and also under Young. Those are part of the circumstances of the arrest, is part of who you stopped. But we don't need that rule in this case, because that's not something that the prosecutor...
So
here was
how
able to
is
elicit.
observing the handing over of the license distinct from observing the defendant sitting behind the wheel of the car?
Because
Not the records tied to it, but the observation of the handing over.
So sitting behind a wheel has nothing to do with who you are. It's not your name. It's not your date of birth. Production of a identification card, as Hibble said, is equivalent to a statement disclosing your identity.
It's the observation of the act, though, that I think you could argue gives rise to the same inference as sitting behind the wheel, which is you're the driver.
Well, the observation of the act of handing over the license is the observation that establishes the identity of the individuals apprehended. So what Tolentino says is the evidence that establishes the identity is the evidence that is not suppressible. And you could separate it out simply by tailoring the questions you're going to ask to the police witness, and basically asking the police witness to testify that the defendant handed over his license, and not having the police witness testify that he was sitting behind the wheel with the keys of the admission. So it certainly is possible to separate these things out in testimony. Tolentino and Streif both turned on the assumption that the officer in the field is permitted to use his knowledge of the name of the person who was stopped. And that is really critical because I think what is driving Tolentino is the recognition from Silverthorne that evidence that is suppressible is evidence that police officers are not allowed to use in the field. And it is very important that the police officer in the field be allowed to make use of his knowledge that the name on the driver's license, the name on an arrest warrant is attached to the individual.
But isn't this about how you get the driver? The police officer doesn't know the name on the driver's license until someone gives them the name on, the driver's license. And that's the non-Tolentino wrinkle here, because someone in Washington, D.C. said, you're arguing it the wrong way. You should argue it this way instead. And now we have that new argument. We're not talking about their identity per se. We're not talking about their name. We're not talking about their driving record, all of which I agree with you. Tolentino says you can't suppress that. But how the police learn it is different, isn't it?
I would say no. I mean, Tolentino does address that. I mean, I think Tolentino talks about identity-related evidence being evidence that is used to establish the identities of the individuals apprehended. If you are suppressing the evidence that the officer needs to know who this person is, then you are preventing the officer from making use of the knowledge of who that person is, because the officer then would be making use of suppressible evidence.
But the argument from the other side would be, well, if the officer didn't have any legal right to make that inquiry and elicit that information, it doesn't matter that they need it. Of course you need it.
Well, I mean, this court in Tolentino decided, based on INS v. Lopez Mendoza, that the individual identity is simply not a suppressible fruit of an arrest.
If there were a determination, I understand there hasn't been, if there were a determination that there was no basis for the stop and you wanted to proceed with the case, could you argue that the handing over of the license is evidence of operation?
No, I mean, I don't think handing over a license is evidence of operation. Handing over a license is quite different from driving a car.
Because it doesn't show the fact, or because it's suppressible?
Because it doesn't show the fact of driving a car. I mean, the act of handing over a license is not the same thing.
But what
But it
about
might lay the grounds for an inference of such.
I mean, it's possible that a jury might infer that the person who handed over the license.
Because normally when the police pull you over, they say license, registration, and insurance card. And that's normally asked of the driver, not a passenger.
Right, but I think the mere fact that an inference could be drawn does not mean that the evidence is suppressible. I would point.
But do you agree that if you had no right to stop in the first instance, anything that one obtains thereafter, other than identity, is suppressible?
Yes, I mean, this is a narrow exception for identity, which simply reflects.
And you're saying because a driver's license is tied to identity, it's permissible?
It's how the officer learned the defendant's identity. And in a number of contexts, courts have treated identity as different from other kinds of evidence. In Hibble,
If I understand, and she'll correct me if I'm wrong on the rebuttal, if I'm understanding their argument is, yes, you can establish that the defendant is David, I'm sorry if I mispronounce the name, Ehinmiakhena. You can establish that David Ehinmiakhena has a suspended license, whatever the violation was. But you can't use the fact that you requested a license from him after the stop to let someone connect the dots that he was driving that car at the time that the officer stopped that vehicle. If I'm understanding their argument, that's their argument.
Yeah, and what we've argued is that the mere fact that defendant hands over his driver's license after the stop is really not enough to prove his guilt of driving a car.
It allows for the inference.
Well, I think it might lend some support for the inference, but in Young, the fact that the defendant.
Are you saying the exclusionary rule doesn't apply to evidence that might lead to that might give you the basis for an inference of criminality or criminal action?
Yeah, I mean, I would point to Young, where the circumstances of the arrest were deemed non-suppressible. The circumstances of the arrest were that the defendant had been stopped and arrested in close spatial and temporal proximity to the robbery that had occurred. So it did lend some support to the inference. Now, in this case, the mere fact that he handed over the license, we would say, is not enough to support a conviction for unlicensed driving.
So is that the only observation that you want to introduce, the fact of the handing over of the license?
Yes, that is all we
And where did you
proffered.
limit that in your papers?
So this is page A13 of the record, and this
Yes.
is our response to the defendant's
Yes.
motion. And what the prosecutor says is, I'm quoting here, the observations at issue after the stop would only be the defendant handing over his
Yeah,
driver's
but that
license
last
that revealed
sentence
his
says,
identity.
under these circumstances, since the defendant's identity is not suppressible, then neither is the observation of the police leading to that fact. So to me, that's an argument for suppression, not an argument for limiting the observations.
Well, what she's saying there is that the observation is simply defendant handing over his identity. That's
No
What
other
she's saying here
observation.
is that the defendant's identity is not suppressible, then neither is the observation of the police leading to that fact. So if we think that you didn't limit the evidence in that manner, would sending it back for a hearing be appropriate in your view?
If we hadn't limited the evidence, then I think, yes, you could send it back for a hearing. But the second argument there, the second sentence you're reading there, is simply a legal argument for why the evidence described in the first sentence is not suppressible. And so the critical sentence for describing the evidence at issue is that first evidence where
There
she
is
says,
another plausible reading. I think you just heard it, right? That's your interpretation of what that phrase means, but they just say observations. They don't link up as concretely as you do now standing here, the observation being the identity portion of the observation.
I don't agree. I mean, the prosecutor says the observations at issue at the stop would, quote, only be the defendant handing over his driver's license. So she uses that word only, and that does restrict the evidence that the prosecutor is offering. Sorry, I thought there was another question.
No, it's fine.
But are you saying that that was not a limitation on what the prosecutor might want to use to establish the legality of the stop? Or am I misunderstanding you?
I mean, my read of the record is the prosecutor made a strategic decision that she could prove the case based on the pre-stop observations and the limited observation of defendant handing over his driver's license. If she couldn't do that, that means she would lose the case.
So then we only have that pure legal question before us.
Yes, that is correct. And, I would just say that, I mean, I think that the reason that this rule really is that identity evidence is just simply treated differently from other evidence. And there's really two reasons for that. Part of it is that, as Hibble observed, there's really minimal deterrent benefits from suppressing identity because a person's mere identity in the usual case is usually not incriminating. And the second reason is that courts have noted that there are unique costs to suppressing this kind of evidence that don't apply to other kinds of evidence. So the classic scenario is the Streiff scenario, where you stop somebody, you find out that that person is named on a warrant for a terrible crime. If you're not allowed to know that the name on the warrant is linked to the name on the person standing right in front of you, then you can't execute
Is
that
it your
arrest warrant.
position that the identity evidence, if it forget the inference for one moment, establishes culpability as direct evidence, that is also not subject to the exclusionary rule? I just want to be clear on your view of the law.
Well, so our view of the law is that what determines whether it's suppressible or not is whether it is the kind of evidence that is used routinely by officers in the field to determine someone's identity. I mean, how strongly it supports or does not support a culpable inference in a particular case is not the basis for determining whether something is suppressible or not. And I think the reason that makes sense as a rule is, like, first of all, we just don't make case-by-case determinations about how inculpatory the evidence is to determine whether it's suppressed. And the other thing is, when we're looking at the deterrence benefit, we want to look at how likely it is that the evidence is going to be incriminating in a particular case. Will the officer who's on the street seeing a car think that the mere identity of the person he is stopping is likely to be incriminating? Hibble says no, that in the usual case, the person's mere identity
You don't
is
think
not
that
incriminating.
calculus changes at all when you're talking about unlicensed operation? I mean, this is not, I agree. If this were a case where someone just, I don't know, stole a grocery bag from someone because they put it down on the sidewalk for a second and ran away, who they are doesn't really matter at all to making out the crime. But here, the crime is inextricably wrapped up in who the person is and what their DMV record is.
Well, I think there's 2 points there. First of all, this is the unusual case where, where somebody's mere identity is related to the crime, but I think you measure the deterrence benefits based on the normal case, not the unusual outlier case. And secondly,
You mean it's unusual because there might have been other pre-stop observations that would have gone to the criminal conduct or the culpability, or is that what you mean?
well, what I mean is that in a usual case, who you are as a person is irrelevant to whether you are guilty of a crime. If you robbed somebody, the fact that your name is John is irrelevant to
Yes.
whether you
Well, that goes
committed
to
the
Judge
robbery.
Canataro's
So-
point that it's the nature of this crime.
Right. And so in the usual case, merely learning somebody's identity is really irrelevant to securing a conviction, and that is why officers are not encouraged to execute stops merely to learn their identities. And as this court and other courts have said, the exclusionary rule is always a highly costly, it's a costly remedy, and we only apply it in circumstances where it has a deterrence benefit that warrants the costs that are incurred when we apply it. And if this court has no further questions, we ask that you affirm. Thank you.
Thank you.
Counsel, if you had testimony of a pre-stop observation the defendant was driving the car, seems to me you can get the DMV records themselves in under Tolentino. Can you get in the officer's testimony that it was the defendant who handed the officer the license, which yields the records?
That testimony would still be subject to a suppression hearing because it's still observations that are.
So if Tolentino says the records are permissible, then how is it that you link the identity of the defendant to the identity of the person in the records? If that specific statement about the defendant was the person who gave me that license is not in.
It goes back to the jurisdictional rule. The identity is not something they need to establish. It's innate in the jurisdiction of the court. Think about it. In most of the
But
criminal
the
cases, they
DMV
don't.
records, though, it seems to me it's a fair reading of Tolentino that the DMV records are not suppressible,
Yes.
right? So what use are they if you can't ascertain who they are tied to?
So this is what Tolentino provides. The DMV records come in. Also, the identity of the person in court comes in. So we know that the person who's sitting in court is linked.
So you
to
can
those
tie it up
DMV.
that way.
That's coming in because of Tolentino. The observation of the handing over is culpable conduct, and it needs to be subject to a suppression hearing.
Because it's proving the act of driving.
Yes, yes. And the idea that you could somehow excise out that limited testimony from the other parts of this very brief encounter it's not possible. And so this case is from 2016. Now it's very common.
What if
that
there's more
we
than
swear
one
body
person in the
cameras.
car and the officer testifies? I asked all of them for their licenses. I ran all the licenses.
Well,
Does that establish that the defendant is the driver? Could you bring that in if there's more than one driver? If there's more than one driver,
there's more than one.
and yes, I'm sorry, more than one person in the car, excuse me,
That would be.
unless you've got the learning car, but
I
they
think
don't do that
all of
anymore
those
anyhow.
observations are what is the subject of the defense.
And the
motion
officer,
here.
I asked all of them for licenses.
Sure, and then that might be, in that hypothetical, then that might be an issue to be resolved by a finder of fact, who the driver was. But in a typical case, in this case,
Draw an inference.
yes.
Just to go back to what you say Tolentino means, person in the court is this person. They have these motor vehicle records saying they have no license. So why then can't they prove the person was driving other than by using the handing over the license?
So they don't need to introduce that handing over information. It's
Right,
not
so they're
necessary.
not going to. Like, they say, let's say they're not going to. They're going to use something else to show the person was driving. But I can use, I think you're saying, when I get to court, you're Joe Smith and Joe Smith had a suspended license.
Right, that aspect is what's covered by Tolentino.
What
And everything else.
what can't you show then? I mean, I'm not saying he handed me a driver's license. I'm saying here's a video of this car going through, and when I stopped it, that's who was in the car.
So if, I think that they could try to establish their case that way. It's obviously weaker evidence than the officer's close-range observations identifying the person in the driver's seat, but they could try to do that. Those camera footage are very grainy. I think it's clearly weaker. So the idea that that they would strategically choose not to just have the suppression hearing and be able to introduce the strongest evidence of culpability is not easy to swallow. Why not? They've said all along that the stop was legal. Do the hearing, get in the strongest evidence. But it is, they're saying that it was a strategy issue. They were going to go without this, but it's a little disingenuous because they also want to introduce this small observation, which is highly inculpatory. So I think they want to have their cake and eat it too, honestly. I want to get back to like the
As a policy matter, how else do you keep unlicensed drivers off the road?
well, I mean, all of these stops should be
Someone's had a license
constitutional.
revoked or...
And there's no reason that an officer who follows constitutional, has reasonable suspicion, pulls over the car, then, that's the proper way to...
Yeah, but then it's not an unlawful stop. I'm not talking about that.
Oh, so, well,
Because the policy here is, I thought you said, to disincentivize unlawful stops.
yes. Okay. So maybe I don't understand your question.
I'm saying the balance between that and someone who should not be on the road, their license is either suspended, revoked, doesn't have one. Though that wouldn't be this case, because then you're not turning over everything.
The Constitution protects, all New Yorkers, from unreasonable searches. The only way to get that driver off the road is to pull him over for a legitimate reason, and then it's, a prosecutable case.
You agree you might have a legitimate reason after an unlawful stop. Let's say, in the hypothetical you were given before, you let them go. And then maybe you see a traffic infraction, then you could stop them.
Again, with the caveat that there may be some attenuation issues.
Well, that's a credibility question, no? If the officer
assuming-
says they didn't signal when they turned.
Oh, yeah.
I let them go, and then they got to the red light and they didn't signal.
Absolutely.
After it went green.
Because they would have that reasonable suspicion, and then, it flows from there. So it's important, though. I just want to say, like, the respondent keeps talking about that they want to introduce how he learned the name. That's not necessary to the proving the case. It does not. And in the Young case, the court was very clear to say that in the circumstances of that case, they would allow in the testimony about how he was arrested. And he was arrested in a totally different location and, not near the grocery store where the robbery occurred. And so the court just, in a weighing and balancing consideration of the evidence, felt that evidence was atmospheric, told the story of how he was arrested, and because it was not inculpatory, it just told the story of how he was arrested, that's why they allowed it in. And the Hibble case that respondent speaks about, also it said that not all cases, it's a typical case. Well, in this case, because it's the incriminatory behavior is involved with the handing over of the license of the driving is the culpable behavior here. It's just a different situation. So each case has to be evaluated separately.
Thank you.
So I wanted to just say one thing too, that now we have body camera footage. And but with body cameras, they're being the subject of suppression hearings every day of the week in criminal court, and they're granting those motions. And these observations that we're seeking to be suppressed here are really the functional equivalent of body cam footage showing the same behavior. So there's really no distinction between the camera footage of the body camera with these observations. And so for that reason, these observations are equally suppressible fruit, and the court below should have granted suppression. Can I just speak to
I
the...
think you've gone way over your time. Thank you.